On December 9th, 2022, before the beginning of the trading day, Finra issued a U3 halt on the trading of OTC ticker symbol MMTLP. The reason given? An extraordinary event related to settlement and clearance. In the previous video, the main focus was the December 6th iteration. Here, we'll go into the exact changes Finra made to the MMTLP corporate action with their December 8th revision. But first, let's take a look at Finra's reasoning for the U3 halt, a rule Finra seems to avoid mentioning, and a multitude of inconsistencies. Finra is permitted to impose a trading halt in an OTC security where Finra determines that an extraordinary event has occurred or is ongoing that has had material effect on the market for the security or has caused or has the potential to cause major disruption to the marketplace or significant uncertainty in the settlement and clearance process. Now, as we read Finra's concerns that contributed to their December 9th determination, I want you to pay attention to the wording. They immediately begin with among Finra's concerns. Finra uses similar terminology 3 times in their March 16th FAQ. I think by doing this, they make it known that they may not be divulging all of their concerns. This way, if they later share more information, they can point to the fact that they said among their concerns. Their concerns were that after December 12th, the MMTLP shares would cease to be DTC eligible. This is in line with the 0-hour December 13th effective date from the December 6th corporate action. What I'm saying is that on both MMTLP corporate actions, Finra uses the word effective in the final sentence. On the first one, it was used in conjunction with share cancellation on December 13th. This has to be true because the first corporate action included the December 14th pay/distribution date, but the effective date manages to align with the incorrect share cancellation date. In the literal sense, the shares would indeed be cancelled after December 12th. The problem, though, is that December 13th was never the MMTLP share cancellation date. But since share cancellation only appears on the December 6th corporate action, it's easy for the uninformed and misled to believe this to be accurate. Using the date from metamaterials, the above is also true. The shares would cease to be DTC eligible after December 12th, but to be precise, Finra should have replaced after December 12th with after the December 14th trading day. Finra gives the correct share cancellation date later in the paragraph. But as the video continues, you'll see that there appears to be an overarching theme. Finra seems to keep the attention away from the fact that the MMTLP shares were always supposed to be automatically cancelled after the end of the December 14th trading day when the next bridge shares were distributed. Also, according to AST, broker-dealers have the ability to settle broker to broker if it came to that, but by using the dates chosen by metamaterials, T+2 settlement could have taken place. The uninformed that are interested in learning what happened can easily go to Finra's FAQ, scan the text, and when they get to the aforementioned section, they can read those first 2 lines and walk away believing that MMTLP would cease to be DTC eligible immediately after December 12th. In my opinion, this was misleading. These posts from the day the first MMTLP FAQ was released are a prime example. They've been altered to obscure the identity of the poster, but as you can see, they give a play-by-play of sorts, explaining what Finra said in the FAQ. It appears that this person read a few sentences at a time and proceeded to convey the information in a corresponding post. The person even posted about the December 14th cancellation date, but they never questioned why the December 14th cancellation date never appeared in either MMTLP corporate action. To paraphrase though, the MMTLP shares were to be cancelled after the December 14th trading day, after which they would no longer be DTC eligible, and the distributed shares of NextBridge hydrocarbons would also lack DTC eligibility. Finra was uncertain about the settlement of MMTLP transactions that might occur on December 9th and or on December 12th. Specifically, if MMTLP continued trading on December 9th and 12th. There was the possibility that investors buying MMTLP might not have realized the shares were going to be cancelled. They might not have received MMTLP before cancellation and also might not be entitled to the next bridge hydrocarbons distribution. Some questions you have to ask yourself. Finra had all of the information pertaining to their reason to U3 halt MMTLP long before the first corporate action. How is it that Finra only recognized this issue before the December 9th trading day? With all of the extra eyes at Finra on MMTLP due to the fraud tips, fraud detection, blue sheeting, and coordinating with the SEC, how is it that Finra could post not one but two deficient MMTLP corporate actions? And finally, there's a sentence in both MMTLP corporate actions that implies that trading would take place after December 8th. Why did Finra include the following line? Purchases of MMTLP executed after December 8, 2022 will not receive the distribution. We'll go into detail about the other changes in the revision, but this sentence alone making it into the revised corporate action on December 8th contradicts what Finra says about wanting to protect investors from buying after less than 1 day afterwards. What did the market expect regarding trading in MMTLP after December 8th? A large and well-known brokerage at the time, TD Ameritrade, and the then Vice President of OTC Markets, Jeff Mendel, are notable sources. The following is from a TD Ameritrade correspondence sent to multiple clients. New long purchases of MMTLP executed after December 8th, 2022 will not receive Next Bridge Hydrocarbons Inc. shares. As such, after market close on December 8, 2022, new long buy orders of MMTLP placed after market close on December 8, 2022 will be routed for review and cancelled. The same correspondence from TD Ameritrade goes on to say new closing sell orders of MMTLP should be routed normally, but there may be liquidity issues on December 9, 2022 and December 12, 2022. Current open long buy orders that are GTC will be cancelled after market close on December 8, 2022. In addition, MMTLP shares will be cancelled December 13, 2022, and no trading will occur. Again, TD Ameritrade is a reputable brokerage. They understood not to allow new purchases of MMTLP after December 8th. If the position close-only transactions on December 9th and December 12th were problematic, why would TD Ameritrade tell their clients otherwise? Next, we go to then VP of OTC Markets, Jeff Mendel. On his December 7th appearance on Trader TV Live, both Jeff Mendel and host Brendan Wickens repeatedly informed the investing public of their interpretation of the MMTLP corporate action. Keep in mind that Finra posted the initial MMTLP corporate action just a day prior. According to Jeff and Brendan, December 12th was the last trading day for MMTLP. Not only that, but they told investors to expect significant volatility. At the time, host Brendan Wickens was at Trader TV Live for more than 8 years, and he had at least 8 years of experience in equity trading. At the time of his appearance on Trader TV Live, Jeff Mendel had been the VP of OTC Markets for 5 years. Trader TV Live has nearly 430,000 subscribers. That kind of viewership combined with the experience and positions of both Jeff and Brendan, you'd think they'd be aware of their reach and their responsibility to properly disseminate information to the investing public. We'll come back to Jeff, but first, we'll do what we didn't do in part 1, and that's to look at the exact revisions that were made by Finra in the second corporate action. To do so, we'll simplify the process by identifying what was included in the first corporate action, and then doing the same for the second. In the first corporate action, there's a December 12th record date. There's a December 14th pay/distribution date. There's a line informing the reader that purchases of MMTLP after December 8th will not be entitled to the distribution. And finally, there's a line that says the MMTLP shares will be cancelled effective December 13th. The second corporate action begins with, "See daily list of December 6, 2022. Does this mean the investing public is supposed to rely on the information contained in both the original corporate action and the revision? If so, what is the point of a revision?" The revised corporate action includes the December 12th date, but it is not referred to as the record date. It includes the same line from the first corporate action, the one that informs the reader that purchases of MMTLP after December 8th will not be entitled to the distribution, and, new to the revision, the last line now reads that the symbol MMTLP will be deleted effective December 13th, 2022. If you're a holder of MMTLP on December 8th, 2022, seeing this revised corporate action, you're likely confused. December 12th is referenced, but why is it no longer referred to as the record date? The pay/distribution date of December 14th is no longer mentioned. Why? Between both MMTLP corporate actions, the only thing that is consistent is the line from earlier about the purchases after December 8th not being entitled to the distribution. Again, isn't it ironic that Finra allowed such a line just to eventually halt trading, as though brokerages wouldn't do what TD Ameritrade planned? What about the notices from TradeZero and Interactive Brokers? They both informed their clients to expect forced liquidations if their short positions weren't closed in the final trading days occurring after December 8th. And look at this response from E-Trade to a client. Aren't these dead giveaways? It really seems like Finra waited to see what brokerages planned to do, but since forced liquidations weren't Finra's desired outcome, they just went with extraordinary event. Essentially, what Finra is saying is that they protect investors and maintain market integrity by ensuring that investors get the information they need from corporate actions reviewed and processed by Finra. But in unique cases, Finra might assume brokerages and investors will not understand Finra's instructions. And in these cases, this is justification for Finra to halt trading. Why not just provide clear instructions? In the event that Finra isn't sure their instructions are clear, why not halt trading, add clarity, and then allow trading to resume? The last detail about the revision, and in my opinion, the most important, is the final sentence of each corporate action. The first corporate action ends with MMTLP shares will be cancelled, effective December 13th, 2022. The second corporate action ends with symbol MMTLP will be deleted, effective December 13th, 2022. Both corporate actions have the effective date of December 13th, 2022, and it appears to be apparent that this can be attributed to the word effective in each of the closing lines of the corporate actions. The MMTLP corporate action was an exchange. This was covered in Part 1, including examples of corporate actions from similar exchanges. The effective date should have been December 14th, with a time that coincided with being after the trading day. The revision was especially confusing because Finra didn't correct the share cancellation date. They didn't mention share cancellation at all. Instead, they include symbol deletion as occurring on December 13th. While former Torchlight CEO John Britta has gone on record saying that Finra knew the pertinent information related to the MMTLP exchange months in advance, we only need to use what Finra portrays to be factual in their FAQ. In the FAQ, Finra claims that the MMTLP corporate actions were consistent with information provided by Meta Materials in their November 23, 2022 announcement. What this means is, it was known to Finra before the creation of the corporate action that December 12th was the intended record date. December 14th, at the conclusion of the trading day, was to be the distribution date, at which time the MMTLP shares would also be automatically cancelled. So again, it's very confusing that Finra chose to use December 13th as the share cancellation and effective dates. MMTLP traded for more than a year, but it was only after the revised corporate action was posted to the daily list on December 8th that OTC Markets gave MMTLP the caveat emptor designation. The reason given was due to public interest concern and potential confusion amongst market participants regarding dates and entitlements for the share exchange published by Finra on December 6, 2022, and subsequently revised on December 8, 2022. Isn't it interesting that after more than a year of trading and after the first corporate action, the caveat emptor designation due to potential confusion regarding dates and entitlements came when Finra posted a revised corporate action with different dates and missing dates that were in the first corporate action? If the caveat emptor designation wasn't specifically related to the confusion caused by the revised corporate action, why did OTC markets wait until December 8th? On November 30th, 2022, then CEO of Metamaterials, George Palikaras, publicly stated that Metamaterials requested Finra to halt MMTLP on December 14th at the close of the trading day, the next bridge distribution date, or to freeze trading on December 12th at the close of the trading day, the record date. There was to be no public trading after the distribution date. Everything stated by Palikaras on November 30th is consistent with the November 23rd announcement from Metamaterials. To my knowledge, he didn't make another post concerning the same subject matter. I draw attention to this November 30th post from Palikaras because it's as close to what we can assume Metamaterials actually wanted in the MMTLP corporate action. The dates were consistent with the announcement from November 23rd, as well as the prior disclosures from Metamaterials. The extraordinary event was not that there was uncertainty regarding the settlement of MMTLP trades after December 8th. The real extraordinary event was that somehow Finra allowed two deficient corporate actions to reach their daily list, essentially nullifying the purpose of having Finra Rule 6490, which provides governance for the processing of company-related actions. You don't have to go further than the general description of the rule to see that it is Finra's obligation to foster cooperation and coordination of the clearing, settling and processing of transactions in equity and debt securities of any issuer with a class of publicly traded, non-exchange listed securities in the OTC market and in general to protect investors and the public interest. Finra's Operations Department reviews and processes documents related to announcements for SEA Rule 10b-17 actions and other company-related actions to facilitate the orderly trading and settlement of OTC securities. Basically, this Rule 6490 is Finra's way of ensuring that corporate actions are carefully reviewed in order to prevent the very thing that happened with MMTLP. Just look at the section on deficiency determination. It says, if company-related action is deemed deficient, the department may determine that it is necessary for the protection of investors, the public interest, and to maintain fair and orderly markets, that documentation related to such SEA Rule 10b-17 action or other company-related action will not be processed. And what is number 5 on the list of reasons a corporate action might be deemed deficient? There is significant uncertainty in the settlement and clearance process for the security. The exact same reason that Finra used when they claimed to discover a reason to U3 halt MMTLP before the trading day began on December 9th. The impression this gives is that Finra's Rule 6490 wasn't followed. One of the reasons why might be what the MMTLP community learned after the halt, that being the December 6th corporate action we thought came from Metamaterials was actually modified by Finra and imposed on the company. If the initial MMTLP corporate action was created by Finra, it would be redundant for them to review it according to their own Rule 6490. On top of that, Finra would have had to be confident that in overstepping this boundary, they were doing so to fulfill their obligation to foster cooperation and coordination of the clearing and settlement process. With everything you've just learned about Finra Rule 6490, ask yourself why Finra never mentioned it in any of their FAQs for MMTLP. Later, we'll see that they do allude to it, but Finra does not cite their own Rule 6490 anywhere in either FAQ. With all that we've learned in over 400 days since Finra U3 halted MMTLP, we're afforded an opportunity to look back and see how the events played out from a multitude of perspectives. Please keep in mind that as we begin to profile individuals and hypothesize as to what appears to have been their involvement, remember that these are merely observations based on evidence predominantly included in this presentation. These are not accusations. The MMTLP community does not encourage acts of harassment, threats, or violence in any form. So if any of the information you learn here causes you to feel a particular way, please channel that energy into activities that can bring awareness to our plight. And if anyone finds themselves in a dark place, please speak to someone. We begin on November 29, 2021, 5:03 p.m. Why this specific date and time? According to a FOIA request granted to an MMTLP community member, this is the earliest evidence of Finra being involved in an inquiry pertaining to MMTLP. In this email from Sam Draddy, Finra's Senior Vice President, National Cause and Financial Crimes Detections Programs, Market Investigations Team, he notifies 3 redacted names at the SEC and informs them that it was Patricia Casimatis, Finra's Vice President of Market Operation, that reached out to a redacted name at the SEC. Draddy notes that Casimatis is included in the email so that they can reach out to her directly. The Patricia Casimates name only appears in one email in the FOIA thread, but one can assume there were further correspondences between the SEC and Casimates just by deductive reasoning. The preferred share placeholder that was distributed to shareholders of TRCH that held their shares through the merger with Meta Materials began trading as MMTLP on the OTC in early October 2021. Of the investors that decided to purchase MMTLP, most Fidelity clients for a time could only do so by calling Fidelity's fixed income department. The restriction would later be removed, and Fidelity clients were able to buy MMTLP normally. Similarly, Charles Schwab clients that held MMTLP noticed that their shares were being held under the fixed income category in their accounts after the alleged NextBridge Hydrocarbons share exchange. One reason why MMTLP might have been classified as fixed income investment is because traditional preferred securities are known as fixed income investments. Now, if we go back to Patricia Casimates, we see that one of her responsibilities include Finra's TRACE, Trade Reporting and Compliance Engine, which is Finra's, wait for it, fixed income platform designed for reporting OTC transactions in eligible fixed income securities. What this means is there's a possibility that Patricia Casimates was alerted via TRACE that the once non-tradable Series A preferred share that was never intended to trade was now trading as MMTLP. Notice that I didn't say illegally trading. We've come to terms with the fact that there is a legal method to trade any security that has an assigned QSIP, but if that process involves the use of fraudulent and outdated information, well, that should invalidate the legality of the process. Combine this with the fact that Sam Draddy is Finra's main authority on fraud. I wouldn't expect Sam to be in the loop unless there was suspicion of fraudulent activity. But here's another twist. Patricia Casimates was involved with Finra's September 14th, 2021 Regulatory Notice 21-32 OTC Symbol Assignment. The specific purpose of this notice was Finra's request for comments because Finra was considering whether they should allow OTC symbols to be assigned to unlisted securities that did not have a valid QSIP identifier. Patricia Casimates, Vice President of Finra Market Operations, was listed as a person to whom questions should be directed. The same notice points out that it's Finra Market Operations that validates OTC symbol requests when there is a QSIP identifier and the appropriate supporting documentation. The notice describes the process as follows. When a member firm executes a trade that is reportable to the ORF under Rule 6622 but does not have a symbol, in the situation described, the member must promptly request that Finra Market Operations assigns a symbol to the security so that the member can fulfill their trade reporting obligations. This process does not involve a Form 211, but instead an OTC equity symbol request form. Was this the form used to request a symbol for the metamaterials preferred share? You know who might know? My guess is Patricia Casimates. Also, from what I've been able to gather, Finra is required to retain OTC equity symbol request forms for at least 6 years. If you're not familiar with the MMTLP FOIA email thread, there's a year-long gap in between Sam Draddy mentioning Patricia Casimates and Richard Boyle's email to the SEC concerning fraud tips related to the MMTLP exchange. On Friday, December 2, 2022, at 10:46 a.m., Richard Boyle of Finra's National Cause and Financial Crimes Detection Program sent an email to what appears to be 2 redacted SEC email addresses and to Jay Gibbon, a principal investigator at Finra with 20 years of experience. The subject line, Metamaterials Inc. MAT and MMTLP/NextBridge Hydrocarbons Inc. The email went like this. Good morning, redacted. I believe you've had conversations with Finra's OTC Corporate Actions team regarding the above issuer and its proposed spin-off transaction. Would one of you have time on Monday or Tuesday to discuss this matter? Finra's Market Fraud Investigations team recently received several tips that appear to have also been sent to the SEC. Below are some proposed times to discuss, but we can work around your schedules if these don't work for you. Thanks. Even though Patricia Casimates doesn't appear to be involved with that email, Richard Boyle does mention Finra's OTC Corporate Action team. He was obviously referring to Finra's OTC Corporate Actions Processing Unit, which is a specialized team within Finra's Market Operations Division. If you've been paying attention, you'd remember that the Vice President of Finra Market Operations that's right, Patricia Casimates. What this means is that in the event of questionable activity related to a preferred share becoming tradable, or maybe a fraud investigation involving an OTC security seeking to enact a spin-off corporate action, Patricia Casimates would likely have a front-row seat to the show, that is, unless she was already on stage herself. Allow this to sink in. From Finra's FAQ. On November 23, 2022, Meta Materials issued an announcement regarding the NextBridge MMTLP corporate action, stating that each holder of its Series A preferred shares, MMTLP, as of December 12, 2022, would become entitled to receive 1 share of the common stock of NextBridge for every 1 share of MMTLP held. Meta Materials also stated that the NextBridge shares would be distributed to MMTLP shareholders on December 14, 2022, at which time all MMTLP shares would be automatically cancelled, and MMTLP holders would cease to have any rights with respect to those shares. In addition, the company stated that the NextBridge shares received in the distribution would not be eligible for electronic transfer through the Depository Trust Company, DTC, or through any other established clearing corporation. Finra says they acknowledged that the Metamaterials November 23rd PR established a December 12th record date and a December 14th distribution date, at which time all MMTLP shares would be automatically cancelled. So we can conclude that Finra acknowledged the December 14th share cancellation date, and they also acknowledge being aware that the NextBridge shares would lack DTC eligibility. Let's move on. As required by federal law, Meta Materials also notified Finra of the NextBridge MMTLP corporate action. Let's pause right here. In the initial paragraph, Finra explains that the November 23rd PR was about the NextBridge MMTLP corporate action. They explain the dates contained in the PR. This paragraph makes the subject matter clear. So when Finra begins the next paragraph with, as required by federal law, Meta Materials also notified Finra of the NextBridge MMTLP corporate action. We know that Finra is referring to the same information. Next is where Finra might have confused a few people. Consistent with the information provided by Meta Materials, on December 6th and 8th, 2022, we'll pause here again. I'm not saying it was intentional. But if you read this sentence without giving proper emphasis to the commas, the sentence appears to say, consistent with the information provided by Metamaterials on December 6th and 8th, 2022. Those, of course, are the dates that Finra posted the first and second MMTLP corporate actions. For the purpose of clarity, Finra could have included in the first sentence the date that Metamaterials notified Finra as required by federal law. But since they didn't, the reader can be misguided into believing that Metamaterials provided the information on December 6th and 8th, 2022. This couldn't be the case because according to Finra's Rule 6490, company-related actions must be submitted no later than 10 calendar days prior to the effective date of the company action. A requesting party that does not submit a completed Finra action form to the department in the manner and form prescribed at least 10 calendar days prior to the proposed effective date of the company action shall be deemed late, and as set forth in this rule, subject to an additional fee before being processed. We know Metamaterials didn't submit the information late. The George Palikaras tweet alone was from November 30th. From that tweet, we know Finra had the information more than 10 calendar days before the proposed effective date of the corporate action. If that wasn't enough, as covered in Part 1, Metamaterials didn't release a PR about the first corporate action until December 7th. Finra posting the initial MMTLP corporate action on December 6th appears to have been a surprise to Metamaterials. If Finra was working with the company, then the PR would have come out the same day or sooner, in my opinion. The sentence continues. Finra provided public notice of the corporate action on Finra's website. Altogether, the first two sentences of the paragraph are Finra claiming that the MMTLP corporate actions posted to their daily list on December 6th and 8th were consistent with the information in the November 23rd Metamaterials PR and the information submitted to Finra from Metamaterials. Depending on the definition of the word consistent, Finra isn't being truthful. Also, by addressing the December 6th and 8th corporate actions together, Finra was able to selectively address what they meant by consistent. At the beginning of the third sentence in the paragraph, Finra makes it clear that the MMTLP corporate actions were their own. It reads, Finra's corporate action notice stated. Then the paragraph continues that the next bridge shares would be distributed to those MMTLP shareholders with settled positions as of December 12, 2022. This information on the first corporate action was somewhat consistent with the November 23rd PR. The first corporate action referred to December 12th as the record date. The revised corporate action did not. This is inconsistent with the November 23rd PR. The sentence ends with, and further clarified that any purchasers after December 8th, 2022, that is, those with trades due to settle on or after December 13th, 2022, would not be entitled to receive NextBridge shares in the corporate action distribution. This refers to the line that appeared in both corporate actions. MMTLP purchases executed after December 8th, 2022 will not receive the distribution. This line was not included in the November 23rd PR, but since the record date was December 12th, this is consistent. New purchases, if they were allowed after December 8th, wouldn't settle in time for the December 12th record date. The notion that Finra included this line to further clarify is laughable. As shared earlier in the video, Jeff Mendel, then VP of OTC Markets, Brendan Wickens, host of Trader TV Live, TD Ameritrade's Corporate Action Department, and many investors worldwide understood this to mean that trading of MMTLP would take place after December 8th. Messages from multiple brokers informed the investing public that any attempts at new buy orders for MMTLP after December 8th would be routed for cancellation. Any GTC orders would also be cancelled after December 8th. The only buying that would have been possible on December 9th and 12th would have been buying to close short positions. Anyone that wanted to sell their shares of MMTLP on those days would only be selling to a short seeking to close out their obligation. This sentence, as it appears in the revised corporate action, is inconsistent. MMTLP purchases executed after December 8, 2022 will not receive the distribution. There's no pay/distribution date in the second corporate action. The December 23rd PR indicates that the distribution date was December 14th. So again, unless Finra has another definition for the word consistent, this passage in their FAQ is inaccurate. The final sentence in the paragraph reads, Finra's corporate action notice also stated that the MMTLP symbol would be deleted, effective December 13th, 2022. That is, when an issuer cancels shares, Finra will likewise delete the symbol. See the company's announcement stating that the MMTLP shares were to be cancelled as of the December 14th, 2022 distribution date of the next bridge shares. Again, notice the wording Finra's corporate action notice. The sentence and the paragraph ignore the inclusion of the December 13th share cancellation date from the first MMTLP corporate action. In my opinion, this is the biggest inconsistency. Instead, Finra refers to the inclusion of December 13th MMTLP symbol deletion date from the revised corporate action. There was no mention of symbol deletion in the November 23rd Metamaterials PR, nor in any other disclosure from Metamaterials. To say that this is consistent with the PR is also inaccurate. Finra justifies the December 13th symbol deletion date by pointing out that when an issuer cancels shares, Finra likewise deletes the symbol. While this is true, the usual procedure is that the shares are cancelled by the issuer, and then the symbol is deleted by Finra either in conjunction or afterwards. This is why on December 7th, a day before the revision, Jeff Mendel said that the ticker would be deleted on December 13th. He specifically used the word ticker, referring to the symbol being deleted. This is consistent with December 13th share cancellation at the time. There's no rule that says symbol deletion can't come before share cancellation, but you must wonder why Finra would insist on including the December 13th symbol deletion date alone. Why not also include the correct December 14th share cancellation date in the revision? We know Finra knew many months in advance, but from the FAQ, they claim to have known at least since around the time of the Metamaterials November 23rd PR. Because Finra never included the correct December 14th share cancellation date, TD. Ameritrade continued to incorrectly inform their clients on December 9th that the MMTLP shares would be cancelled on December 13th. If the MMTLP situation is as complex as so many have said, deleting the MMTLP symbol before cancellation would have likely made the situation worse. This is why when Finra claims that it was coding error to blame for the D1 deletion code not appearing until 2 months after the halt. A famous quote from French author Alexandre Dumas goes as follows: "No one can tell a single lie. It takes 20 to guard it." The December 13th share cancellation date on the first MMTLP corporate action was a lie. The next day, the Metamaterials PR informed investors and brokerages that the dates from Finra superseded their own. Finra knew they were wrong. Instead of correcting the inaccuracy, they told more lies disguised as coding errors, investors not understanding corporate actions, and lies of omission in an effort mislead the investing public and those that might come to our aid. Along these same lines, at the beginning of the FAQ, Finra leaves out important information and contradicts themselves. Federal law requires that the company submit notice of the corporate action to Finra, and Finra reviews the submission and publishes a notification about the corporate action to the marketplace unless the submission is deemed deficient by Finra. This function helps to keep investors and the market informed of corporate actions affecting OTC securities and of relevant dates. For one, they describe Finra's Rule 6490 review process, but they never direct the reader to the rule. The number 6490 doesn't appear in either corporate action. Why? because most people that read the rule will wonder why the issue related to settlement and clearance wasn't discovered in the Rule 6490 review. Secondly, they describe the 6490 review as helpful to keep investors and the market informed of relevant dates. Finra never included the correct MMTLP share cancellation or effective date on either MMTLP corporate action. If an investor relied solely on the revised MMTLP corporate action, they would never know the share cancellation, distribution, or the effective date of the exchange. Even the record date wasn't given a title, so there'd likely be new investors that weren't aware it was December 12th. Weren't these days relevant?